All right, moving on. Washington state law prohibits licensed counselors from discussing certain topics related to gender identity and sexuality with their minor clients, even when they're pursuing goals that their clients might have come in with and set for themselves. You could have a 14-year-old who is experiencing some gender confusion or concerns about same sex attraction. Those sorts of things could be discussed. The family could be, faith based and seek out a Christian counselor, as often happens. And yet, in the state of Washington, even if that child comes in and says, I'm confused. I don't feel like I'm in the right body, but I don't want to begin a gender transformation. Well, in this state, that counselor is not allowed to counsel that minor child in that direction. They can only, in the state of Washington, embrace the gender ideology toward changing one's gender. It's been a law here in the state of Washington since 2018. But Brian Tingley, a Christian marriage and family counselor, challenged the law as a violation of his First Amendment free speech protections. Now, federal courts dismissed his case. Alliance Defending Freedom took it on in 2021. It was denied by the federal courts, and then the U.S. Supreme Court declined to take his case in 2023. But we fast forward to March of this year, and the Supreme Court ruled 8-1 in favor of a very similar case out of the state of Colorado, with a counselor challenging that state's law over this very same thing. And again, this is the Childs v. Salazar case. 8-1, Supreme Court ruled in favor of the counselor, condemning the viewpoint of discrimination of this law in Colorado. And that paved the way for Brian Tingley to be able to reopen his case. And that's where they're at now. So here is Alliance Defending Freedom attorney on this case, Johannes Vidmalm Delphonse. They represent Brian Tingley.
Absolutely. Well, Washington state law, it really boils down to government enforced viewpoint censorship. Counselors are allowed to help a client transition. They're allowed to support a client who wants to engage in a gender transition, but they're not allowed to help a minor client who wants to achieve comfort with their biological sex. Literature is clear that most children and likely most adolescents who go through this, the gender dysphoria will naturally resolve itself if they're left alone and if they're not pushed into an identity that is inconsistent with their biological sex. But Washington mandates one view, the so-called affirming view, and prohibits the religiously informed or the scientifically informed view that it's better for these children and young people to grow comfortable with their biological sex instead of rejecting it.
So, again, in light of the Colorado U.S. Supreme Court ruling, Brian asked the federal court here in Washington to reopen his case so that he can freely counsel minor clients who might be struggling with gender confusion. And the court decided last month in July, okay, based on the U.S. Supreme Court ruling out of Colorado and this other matter that's very similar to Brian Tingley's case, they've agreed to reopen. And so there's no timeline yet when arguments might take place again or the legal course forward on this. But it's a big win at this point for Mr. Tingley and ADF, because right now he's been told he can go back and operate like he did before and counsel his clients as he was before the 2018 law change.
Well, Washington, they did just agree to a preliminary injunction that would protect Brian Tingley during the pendency of this case. So we think that's huge. I mean, as of right now, Brian Tingley is free to speak consistent with his beliefs and his clients' beliefs on these topics for the first time in 5 years. And in terms of when the case will resolve, that remains to be seen. I mean, we hope that Washington will do the right thing and agree to no longer enforce these problematic provisions of its law, allow counselors to help clients with their own self-determined goals, and respect the Constitution. But that remains to be seen.
Again, no timeline as yet for this case to go back to federal court, given the Colorado U.S. Supreme Court decision now in the mix. But we're going to be following this very, very closely.